made against him of repeated rape and abuse should be made public. The court, in its judgment, found that I had been subjected to the vilest abuse and that Andrew Griffiths had used his power, his position of power, to cause the utmost physical and emotional distress against me. Madam Deputy Speaker, those who know me well will know that usually I am a very private person. The thought of allowing reporters to write about what had happened to me, very private details, many of which I'd covered up for years, was a terrifying thought. But after years of being bullied and controlled by a seemingly powerful man, I knew that I had to stand up and use my platform to help others.
Can I just, at this point, commend my honourable friend for her strength and her courage and her tenacity, and for speaking up today on this important issue with personal experience. She's a great role model for us all.
Thank my right honourable friend for that. Despite the landmark ruling that I achieved, my time within the family court system was far from over. Despite the court confirming that my child's father was abusive, a rapist, it was decided that contact should continue through a contact centre and that I should pay for 50% of the cost of that contact. I couldn't believe that anyone felt that my child, whom I'd been fighting to protect, would benefit from further contact with such an abusive and violent man, and that I, someone who'd been subjected to that violent behaviour, should not only facilitate that contact, but also pay towards it. Thankfully, after furtherly costly and lengthy legal proceedings, a ruling was made to overturn that decision and hopefully set a precedent that a victim of rape should not have to subsidise the rapist's costs of contact. Despite the public reporting of my case, I've not been able to speak freely of my experiences until the final decision was made. However, after a gruelling 5 years, a ruling was delivered last month that confirms that Andrew Griffiths, the former MP and Minister, should no longer be allowed contact with his child, my child. I had finally achieved a ruling to make the case that the man who had abused me over a 10-year period was not safe to have contact with our child. I'm really thankful that these proceedings have now concluded, and whilst I am traumatised, not just by the 10 years of abuse I experienced at the hands of my ex-husband, but the following 5 years, where he continued to use the legal system to abuse me. And I won't waste any more time in telling my story and trying to make changes to help other women protect their children. These were landmark rulings. Landmark rulings because until now, other victims of domestic abuse, violence and rape have not been able to offer protection to their children in the same way, or to talk about their family court experiences. And having lived with the thought of that prospect for many years, I can only imagine what it feels like to hand your child over to someone who has caused you and continues to cause you so much harm. I stand in the chamber today as a supposed winner, congratulated on succeeding against my ex-husband. But, Madam Deputy Speaker, I stand here, quite frankly, drained financially and emotionally. I'm not sure that this is what people believe winning feels like. But I know what the alternative must feel like, and I will do all I can to stand beside those fighting for their children's safety. I want to give them hope that this government recognises the problems in the family court and is determined to help. Of course I will.
Madam Deputy Speaker, can I commend Honourable Lady for Burton for bringing this our personal story? I spoke to her beforehand in relation to it. I thank her for using the platform today of this House to tell her personal story. It takes real bravery to stand up and not only speak about an issue that means something to you, but one that you've lived through yourself. The Honourable Lady has shown exceptional courage in doing so, and we all admire her for that. But does the Honourable Lady agree, and I think it's coming to the crux of the question because we asked her, we discussed this beforehand, that in so many cases victims of domestic abuse are absolutely terrified to speak up, and that more encouragement must be done by our Minister of Government and by our fellow MPs as well to ensure there is no prolongment of trauma and that women feel supported to speak up, and by doing so encourage others in similar situations that they're not alone. You're not alone, Honourable Lady, and you can be sure of that.
I thank my honourable friend for that, and I absolutely agree with that point. Domestic abuse is something that happens behind closed doors, and if people don't speak out about it, then those perpetrators know that it's going to stay behind closed doors. And that's why I agreed to the publication of my judgment, in the hope that it will encourage more people to speak out, and it will help victims and survivors in the future. I am proud of the work that the government's done. I'm proud that the party I belong to is the one to have introduced the Domestic Abuse Act, which was an incredibly important piece of legislation. The Act provided the much-needed clarity. Domestic abuse comes in many forms. It can be financial, verbal, emotional, as well as physical and sexual. And it also recognises that abuse can be a result of patterns over time, and as part of the definition that children are explicitly recognised as victims if they witness that abuse. The Domestic Abuse Act also allowed for a Domestic Abuse Commissioner to be appointed to stand up for victims and survivors. And I want to pay tribute to the work of Nicole Jacobs, the Domestic Abuse Commissioner, and her team. They worked tirelessly to stand up for victims and survivors and to raise public awareness and monitor the response of local authorities, the justice system, and other statutory agencies, and to hold them to account in tackling domestic abuse. I'm also grateful for the chance to work with the Commissioner and to contribute to her report on achieving cultural change in the family court. Beyond the Domestic Abuse Act, the government have continued to listen and learn from the experiences of domestic abuse victims. In May 2019, the government announced an expert panel to look at how the family courts protect children and victims in child arrangement cases relating to domestic abuse and other serious offences. The panel's final report was published in June 2020, the Harm Report, Assessing Risk of Harm to Children and Parents. And it raised concerns about how the family court system recognises and responds to allegations of and proven harm to children and victims' parents in private law proceedings. The report went on to state, submissions highlighted a feeling that abuse is systematically minimised, ranging from children's voices not being heard, allegations being ignored, dismissed or disbelieved, to inadequate assessment of risk, traumatic court processes, perceived unsafe child arrangements, and abusers exercising continued control through repeat litigation and the threat of repeat litigation. The report said these issues were underpinned by a number of themes, including a pro-contact culture. That report was released almost 4 years ago. Let's ignore for a second that at the heart of this report it confirms that victims of domestic abuse are being further traumatised by the court process. But let's look at the potential harm to children. Their voices are not being heard. Inadequate assessment of risk and unsafe child arrangements. Perhaps in his response, the Minister might consider how much harm to children has taken place in the 4 years since those findings were made. The report echoes many of the experiences the women who have contacted me have shared. Respondents felt there was little difference in the orders made between cases that did and did not feature domestic abuse, and the courts almost always ordered some form of contact, frequently unrestricted and usually without requiring an alleged abuser to address their behaviour. That orders made by the court had enabled the continued control of children and adult victims of domestic abuse by alleged abusers, as well as the continued abuse of victims and children. The respondents also raised concerns that PD 12J, the practice direction that sets out what the court should do in any case in which domestic abuse is alleged or admitted, is not operating as intended and is being implemented inconsistently. Regarding the presumption of parental involvement specifically, many mothers felt that the presumption gave the abusive parent power over the non-abusive parent and children and was a legal weapon the abuser could use at will. They also felt it put a misplaced emphasis on the child's right to a relationship with both parents and the father's right to a family life above the child's welfare and the right to be safe from abuse and its effects. Overall, the report said, the evidence received by the panel suggests that the presumption is implemented inconsistently and is rarely disapplied, to the extent that the court's pro-contact culture operates as a barrier to addressing domestic abuse and serves to reinforce that culture. The report recommended that review of the presumption of parental involvement is needed urgently in order to address its detrimental effects. An urgent review is needed, urgent because of the risk of harm to children. Yet almost 4 years on, we're still waiting to hear about that review. The government had originally expected to complete the review by the summer of 2021. I met the then Justice Secretary in 2021, offering my support to his team to help them make the positive changes needed. In early 2022, I was advised that the review had been delayed by COVID-19, but reassured that good progress was being made in taking the work forward. When I raised the matter in this House in early 2023, I was advised that the response to the review would be published very soon as we can do so. In mid-2023, in a further update from the Justice Secretary, I was advised that it had taken longer than expected, but the report would be published later that year. And in a response to a parliamentary question in November 2023, the Minister then advised it would be published in early 2024. How many court hearings involving children at risk of abuse have taken place over the years whilst we're waiting for the review? A horrifying example was raised previously in this House, where 2 children were murdered by their father after it was ruled it was in their interests to maintain contact with him. In answering the question, the Minister went on to explain that the review has to be carefully considered because of the complexities of parental involvement. This feels like we are prioritising the needs of the abuser again. Why not, whilst we're awaiting the review, prioritise the safety of the child and change the presumption? Where there's been a history of harm, the onus should be on the parent, the abusive parent, to prove that they should have that contact, not the other way round. Imagine having the courage to escape a relationship, to keep yourself and your children safe, and putting your trust in our legal system to continue those protections, only to find yourself locked in a further battle with a court who prioritises the right of an abuser to see their child over the safety of the child itself. Despite everything I have been through, I know that I'm lucky. Many would give anything to have received the judgment I did. I'm grateful to have had a fantastic legal team, Melanie Bridgen, my solicitor, and Charlotte Proudman, my barrister. And Dr. Proudman is an incredible advocate on behalf of survivors of domestic abuse and has founded the organisation Right to Equality, who are also campaigning for a change in this pro-contact culture. They state that family law reinforces a cultural and legal norm of parental responsibility for both parents, even in cases involving rape and murder, by parents, often fathers. They believe this approach fails to adequately consider the safety and well-being of survivors and their children, perpetuating an environment that can place them at risk. Under the law, as it currently stands, a married father can never have his parental responsibility removed, even if he killed the child's mother or violently assaulted the child. There are many case law examples which show where survivors' pleas for protective measures are disregarded and which highlight the need for the government's urgent attention to fixing our statute books. Research conducted by a team led by the University of Manchester spoke to the 45 mothers of 77 children, all of whom reported experiencing abuse. But perhaps the most alarming finding of the study was that 75 out of 77 children were forced into contact with fathers they had reported for abuse, even in cases involving sex abuse convictions. This government, who has done so much for victims of domestic abuse, needs to fix this existing statutory and de facto presumption of child contact at all costs. I urge the Minister to bring forward his review without further delay, to bring about legislative change that creates a safer environment for children, and support a presumption of no child contact in cases where domestic abuse is a relevant factor. The Minister's review did not come quickly enough to help me, and I too was dangerously close to being let down by our legal system. Through using every penny I could get my hands on and every ounce of resilience I could muster to stand in court and repeatedly tell my story, I was able to achieve a landmark ruling. It shouldn't be the exception that only my child has protection from a man found by a court to have committed multiple accounts of rape and abuse against the mother. This should be the standard. It should be a clear message to those who carry out acts of abuse. It doesn't matter whether you're an MP or have any other public profile. If you are found by a court to have raped or abused the parent of your child, you are no longer entitled to assume that that child will benefit from contact with you. I ask the Minister today, reform this presumption urgently. Contact should be earned. It should not be given to abusers.
Minister Mike Freer.
Thank you, Madam Deputy Speaker. First of all, may I congratulate my honourable friend for Burton on securing this important debate this evening. And I would like to sincerely commend the bravery that she has shown by sharing her story and for using her experiences to support others in similar circumstances. Madam Deputy Speaker, I often find that this House is at its best when colleagues from across the House use their own personal experience to help shape legislation and improve things for other people who follow us. If I may also apologise that some of what I say will sound rather cold and clinical, but sadly the law isn't always warm and friendly as much as we would like it to be. So I will come on to the presumption of parental involvement, but I would also like to begin by saying that the acts of abuse perpetrated by the ex-partner of my honourable friend were clearly and totally abhorrent. Sadly, the frequency and intensity of violence, psychological abuse, sexual assault and other types of domestic abuse within households is the horrific reality for too many people in this country, and particularly, although not exclusively, for women and girls. The government, including myself and my noble friend Lord Bellamy, are committed to taking every possible action to stop this and to allow victims of abuse and their children to live free of the fear and harm inflicted by their abusers. When such cases come to the family court, this government is dedicated to ensuring that the court can identify and safeguard both children and parents against such abuse. When the court makes a decision that affects a child, the involvement of parents is often a factor. However, it is the welfare of the child that is the court's utmost priority in every case. And that principle of paramountcy of the child's welfare is what underpins the Children's Act of 1989. The court does seek to protect the adults in a child's life from harm, and for cases involving domestic abuse, the provisions of this are also enshrouded in our laws and rules of court. For example, the landmark Domestic Abuse Act of 2021 prevents cross-examination of victims by perpetrators and requires rules of court to be made about special measures for victims, such as screens to prevent them from seeing the perpetrator in court. In family courts, Practice Direction 12J, as my honourable friend mentioned, notes that the court must be satisfied that any order does not expose either the child or parent to risk of further harm. Therefore, whilst the welfare of the child is absolutely paramount, the welfare of parents as parent victims is very much as equally important consideration of the family court and of the government. If I may, Madam Deputy Speaker, move on to presumption of parental involvement itself. The government is very mindful of the need to ensure that where it is safe, a child should benefit from the involvement of both parents in their lives, but I do stress where it is safe. The aim of the introduction of the statutory presumption in 2014 was to codify decades of existing case law and international commitments, and to place in law a process whereby the potential risk posed by a parent is fully considered and only subsequently in their involvement in child's life considered. The presumption is therefore designed to achieve two vitally important aims: to ensure that, when safe, children are able to maintain some form of relationship with both their parents, even when they separate, and to ensure that parents who may subject their child or ex-partner to the dangerous and despicable behaviours inherent in domestic abuse are prevented from involvement in their children's lives. In the example given by my honourable friend of the serious and horrific cases involving sexual abuse, when the parents in these cases present a risk of harm to their child, they should not be granted involvement in their life. My honourable friend has also raised the terrible circumstances in which one parent has murdered the other. We have amended the Victims and Prisoners Bill so that parents who kill a partner or ex-partner with whom they have children will have their parental responsibility suspended upon sentencing. We are carefully considering options for strengthening the safeguards and procedures already in place to ensure the family courts can properly protect children, ensuring the survivors of domestic abuse are fully protected by the family court, and that remains a priority for this government. In 2019, the Ministry of Justice commissioned a review of how the risk of harm to children and parents was assessed in private family law, most commonly known as the Harm Panel report my honourable friend referred to. Following the recommendations of the panel, we commissioned a further review of how the presumption of parental involvement was being applied in the family courts. I know that the honourable member, like several others in this House, has expressed concern over the time taken to complete the review. And if I may, Madam Deputy Speaker, I can put on record that ministers in the department share that frustration of how long it has taken to bring forward our response. As my friend said, the delay is in part due to COVID making it difficult to conduct research, particularly in terms of accessing physical court files and the challenges in accessing court documents that are in a usable format. However, Madam Deputy Speaker, I am delighted to be able to confirm that the review and the accompanying government response into the presumption of parental involvement will in fact be published by late spring or early summer of this year. So I hope that provides some reassurance that at least we have a slightly firmer date coming forward, because I can, as I've mentioned, reassure that ministers are equally frustrated that we bring the response forward. And I would like to assure my honourable friend that the Ministry of Justice is giving full consideration to a literature review of the academic evidence, the sessions conducted with parents who have been through the family court, the individual case file analysis, the contributions from stakeholders and the feedback from the advisory board. Because that board was established to ensure that we have drawn upon their expertise of working with victims and children. The challenge of striking the right and careful balance between addressing the future risk to the child and the other parent and the benefits of having two parents actually involved in the child's life is one that has occupied Parliament, the judiciary and wider society for decades. It's crucial that in setting out next steps from the review, we consider the full range of reforms at our disposal to manage this challenge. We must ensure that the understanding of these elements of risk and the best interests of the child in these cases is always clear, and the balance of these elements is struck correctly. If I may, Madam Deputy Speaker, just reiterate a few things that the government have done to ensure that the child is at the centre, but also that the family court system continues to reform and continues to be fit for purpose, ensuring that parents, especially children, are protected. And that's why last week the Chancellor announced an additional £55 million for the family court. And a key element of that funding package is the commitment to funding the rollout of the Pathfinder Court approach that provides a much more investigative approach to private law proceedings with increased support for parties. The pilots engaged domestic abuse agencies early on in proceedings to ensure both parents and children are receiving the support and advice they need. And the approach also ensures that the needs and voice of the child are absolutely central to the proceedings. And this is achieved through detailed investigation into each individual child's welfare, and which is early on in each case. And the Pathfinder courts are currently operating Dorset and North Wales and expanding to Birmingham and South East Wales in a matter of weeks. The additional funding will also mean more families will benefit from the positive impacts of this model, with a rollout of the Pathfinder model across England and Wales happening as quickly as possible. The additional funding will also see the creation of a new authoritative online support and advice service for separating parents and the piloting of free early legal advice for those considering court to resolve their issues. Over the last 13 years, Madam Deputy Speaker, we have also significantly increased the funding for independent domestic violence advisors, known as IDVAs, and independent sexual violence advisors, known as ISVAs, to support victims going through the family court. We brought 43% more of these vitally important professionals into post from 2009, 2010 to 2023, with the Ministry of Justice increasing IDVA and IDVA spending by over 4 times what it was in 2009-10. And since November 2023, we have also increased our investment by 1.2 million over 2 years. If I may, rather than read out many more statistics, I would also address one of the issues that my honourable friend raised, which is the cost, the actual financial cost, not alone the mental cost. And that's why we have been reforming the access of legal aid to victims of domestic abuse. And recently we have changed the thresholds for income and capital. We've introduced a new lone parent allowance. We've created a mandatory disregard of inaccessible capital from the means assessment. We've removed the cap on the value of capital assets that are not considered in the means test assessment when they are disputed assets. And finally, we've extended the equity disregard to apply to those who are forced to flee their homes. And that will prevent victims who may be on a low income from having to sell their homes. Madam Deputy Speaker, I share the frustration of my honourable friend, and I have to say that her story and her campaigning has been incredibly moving. And I hope that this government will be able to address her concerns in the coming months when we do finally publish our response to the report. Those who have perpetrated abuse against their partner or ex-partner should absolutely feel the consequences of that actions. Our reforms of the family courts will continue to increase the support for survivors of domestic abuse and aim to ensure that both parents and children are protected against the abhorrent crime of domestic abuse. If I may, finally, Madam Deputy Speaker, thank my honourable friend for Burton again for bringing this debate to examine these issues, and I hope that we've gone some way to explain how seriously the government considers them and how seriously we are committed to bringing forward our response in the next few months. Thank you.
The question is that this House do now adjourn. As many as are of that opinion say aye. The ayes have it. Order. Order.
Has ended. The proceeding 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 has ended.